Okay. And Fred, are we live? And we are live, Chief.
Alrighty. The court calls the case of DiCesare et al. Versus the Charlotte-Mecklenburg Hospital Authority. We welcome Mr. Glacken and Mr. Cooney and everyone who's joining us for these historic virtual oral arguments. This is the first time and the second day this week that the court has hosted virtual arguments in its 200-year history. Mr. Glacken.
Thank you very much, Madam Chief Justice. Good morning, justices and members of the court staff. My name is Brendan Glacken. I represent the plaintiffs and appellants. May it please the court, I will be devoting 10 minutes at the outset to discussing the direct appeal on the Chapter 75 issue, and then hopefully, subject to the court's questions, reserving 20 minutes for rebuttal on Chapter 75 and for response on the petition for certiorari. On the Chapter 75 issue, the question before the court is whether or not a quasi-municipal corporation, in this case a hospital authority, is categorically exempt from the reach of Chapter 75, Section 16, which provides the damages remedy for enforcement of North Carolina's antitrust laws. Judge Robinson, to my mind, somewhat understandably found that he had no choice but to follow the North Carolina Court of Appeals' decision in Baden Shores versus Handy, holding that quasi-municipal corporations are so categorically immune. The answer, however, according to the plain terms of the statute, is that quasi-municipal corporations are not exempted from the reach of Chapter 75-16. And we know this for a number of reasons. First of all, one need look no further than the simple language of the statute, which brings within its reach all persons, firms, and corporations who violate the antitrust laws. But Atrium has been proclaiming now for years on this matter that it is a quasi-municipal corporation. It is a body corporate, in addition to also being a body politic. As such, the plain words of the statute allow a private plaintiff to assert a claim against Atrium for violation of the antitrust laws. Now,
is your argument on that, to that effect, premised solely upon the fact that the word corporation appears in both its legal, Atrium's legal description and the statute?
It is, and also on the fact that authorities have been found to be quasi-municipal corporations. I don't dispute that, and I never have. So, I mean, a quasi-municipal corporation has been found to be a body corporate for all kinds of purposes. And so, yes, it is premised on Atrium's regular admissions about that. It is premised on the statute, which describes hospital authorities as bodies corporate and politic. And it is premised on many cases describing authority-type organizations as quasi-municipal corporations. So that would be, frankly, Atrium never responds to this argument in their papers, so it didn't get a lot of airtime, but sometimes the simplest and most straightforward application of the statutes is the best way to go.
Well, again, I'm sorry to interrupt you so quickly, but I don't want to get lost. It seemed to me that Atrium argued, for example, that virtually any kind of governmental entity would fall in the category of a body politic corporate or something like that, and that if you were to use corporation as used in the statute as a test for determining whether a body was covered or not, that literally every governmental body in the state would be made subject to Chapter 75, and that therefore that couldn't have been what it meant, therefore it didn't say that. I mean, Mr. Cooney can correct me if I've misstated his argument, but I thought he did make that.
So, Your Honor, they made, I'm sorry.
I said, am I wrong in thinking that they did in fact respond to your argument in that way?
Respectfully, Your Honor, I believe you're incorrect, because the argument
wouldn't be the first time.
They did make the argument that allowing they made that argument as quote unquote context for not reading the term person to reach a quasi-municipal corporation, because Chapter 12, Section 3, subparagraph 6 says that you can ignore the definitional statute if clear context shows to the contrary. But I'm starting out not with the definition of person, which has that limitation and is subject to some possible interpretation. I'm starting out with the word corporation, which is a word we all learned in our first year of law school. And that point, that Atrium is a quasi-municipal corporation and thus explicitly within the reach of the statute, is never addressed in their papers to my knowledge.
Is any, in your view, is anybody in the sense of an entity that is labeled a corporate entity, is it subject to the statute?
Your Honor, so I believe that if the court were to rule on this ground, I do think it would bring into the reach of the statute any authority type entity that's labeled a body corporate. I think frankly and candidly, it would bring into the reach of the statute municipal corporations, which are also bodies corporate, in addition to being bodies politic, because they have to have corporate powers. They have to be able to buy and sell and enter contracts and be held liable in tort. They need to operate as corporations. Another way to think about it is that what a corporation is it's a legal fiction created by the state. Private corporations are private legal fictions created by the state. Municipal corporations are public fictions created by the state to do the state's business. So I think a ruling on our favor on the term corporation would bring within the reach of the statute all quasi-municipal corporations, hospital authorities, housing authorities, and so forth, as the court as has happened in the past under the word person. I think that it would avoid, for the moment, the issue of whether or not the state is subject to the statute, because
what's your opinion as to whether that interpretation would bring the state under the statute?
I don't think the state is a corporation. The state is not a body corporate and politic. The state is a body politic. The state is a sovereign, and the antitrust statute, the antitrust decisions themselves recognize that distinction between the state, which is a sovereign entity, and sub-state actors, which do the work of the sovereign entity. So the state qua state would not be brought, I don't think, by that ruling within the ambit of the statute.
I have a quick question. You've used the word body politic a couple times. How do you define a body politic, and where do you get the definition from?
No, I don't. I'm sorry, Your Honor. I don't have a firm. I don't have a good answer for that question. I think that the both Parker versus Brown and FTC versus Phoebe Putney, because of the nature of those decisions, have a pretty extensive discussion of the difference between a sovereign and sub-state actors. And I think that's a useful place to start in terms of understanding what a body politic is. To me, a body politic is a sovereign.
Does it have, does the definition imply any powers or any qualities that would generally be applicable to a body politic, such as participation of the public or anything like that?
A body politic, that's a good question, and I'm hesitant to answer it because I haven't thought through what the answer would be. You know, I mean, I can sort of refer back to my own understanding of you know, foundational political theory texts, but I don't know that those are instructive. I do think it's pretty. I do think that there's a clear difference between the state as a pure sovereign, and again, I mean, Parker versus Brown recognizes this distinction very clearly, that there's a difference between the state as a pure sovereign, and then later decisions interpreting and enforcing the antitrust laws against sub-state actors. That's the foundation for the state action immunity doctrine, is that the state qua state cannot violate the federal antitrust laws.
Well, I mean, given that in North Carolina, municipalities and counties are, as a matter of law, essentially established by the state and agents of the state, how does that logic apply in the kind of constitutional structure that we have?
Well, they are both bodies politic and bodies corporate, right? They are not private corporations. They're bodies politic and they're bodies corporate. And as bodies corporate, as corporations, they are subject to 7516 by virtue of its inclusion of the word corporations. And if that were to be, if there were any doubt about that or any question about it, you could also refer to the term person, which specifically includes bodies politic and corporate in its ambit. And that would bring within it quasi-municipal corporations, just as the court found it did in Jackson versus Housing Authority, where it allowed a punitive damages claim under a wrongful death statute against a housing authority. First I would look at the word corporation. If there were any doubt about it in this case, then you could look at the word persons. That would be the ordering of it. I've used my 10 minutes, but I'll continue. I'm happy to continue answering questions.
Well, the definition section includes the state, right?
I think there's a good argument that it does.
Where would the line of demarcation be if the governmental entity which you identify as the sovereign actually created the entity such as Atrium here?
The line of demarcation is that, and what's really helpful about the state action immunity doctrine is that there are, decades now of cases sort of grappling with these issues that provide a framework for people to follow. The line of demarcation is under the state action immunity doctrine that when the state acts as the state, meaning the legislature passes a law, this court issues an opinion, other sort of top level state authority wields powers of the sovereign, the antitrust laws don't apply. Whether you read that from a concept of federalism or a concept of implied repeal, all sub-state actors, which would mean entities created to do the business of the state, if you will, would be brought within that the ambit of the statute. And then you would have to ask yourself, well, are there conditions under which they should not be liable? Which is the question the court addressed in Madison Cablevision. The court answered the question one way in Madison Cablevision under what I would, it went about as far as implied repeal doctrine goes. It did not reach the state action immunity doctrine. The court could decide this case that way also, because the lower court has already found, and there's no contention that Atrium's conduct in this case is explicitly authorized by statute. The court could also go a step further and adopt the state action immunity doctrine, which would lead to the same result. If there are no further questions, I'll rest for the moment and reserve the balance of my time for rebuttal and the petition for certiorari. Thank you.
Thank you, Mr. Clackland. Mr. Cooney, it's my understanding that you will make a 23-minute initial argument and reserve 7 minutes of rebuttal time. Are you there, Mr. Cooney?
You're muted.
Mr. Cooney, you're muted. You could unmute yourself, please.
Let me try. Can you hear me now?
Yes, we can hear you.
Oh, okay. I apologize.
That's okay.
So
was
yes,
that
I
a
mean-
correct? Was that a correct delineation of your argument?
Yes, Madam Chief Justice.
Okay. Thank you, sir. You may proceed.
Thank you. To please the court, I'm Jim Cooney of the Mecklenburg County Bar, and I represent the defendant, the Charlotte-Mecklenburg Hospital Authority. Justice Hudson, what I'd like to do is address your question. You asked what a body politic was and whether there were certain duties inherent in it. We need look no further than the Byrd decision that the court issued in 1972 involving the University of North Carolina system. And at that time, the phrasing that was in the university system was a body politic and corporate. Those are important words. It's not just the corporate, it's the body politic and corporate. Because what this court said is the words body politic and corporate imply an entity operating as a government. with the obligations and the duties given to it by the General Assembly. As Justice Ervin pointed out, in this state, the only sovereign is the state. In cities, counties, towns, and special function units like the hospital authority all derive their powers directly from the sovereign, and there is no inherent sovereignty or really inherent difference between a city, county, town, and an authority. So what this court has said is a body politic and corporate is effectively acting as a government. The other thing that Mr. Glacken's argument misses when he focuses on the word corporate is the fact that this is a public body. It is declared to be a public body in 3 different places in Chapter 131E. It was declared to be a public body in its initial charter. And what we are saying is that public bodies were excluded from the reach of 7516, that the General Assembly did not intend public bodies to be subject to private lawsuits for treble damages. Now, Mr. Glacken's used the word, yes.
I'm sorry, how do you define a public body?
A public body, I think, is another way of saying body politic and corporate. I think it's a synonym for it. It's a public body in the sense it is subject to the public records laws, it's subject to the open meetings laws, it's subject to supervision by the local government commission. The county commissioner appoints the board of commissioners. The county commissioner can remove individuals from the board of commissioners. The hospital authority even has the right of eminent domain as a public condemnor. So there's no question it's a public body. And in that sense is no different than a city, a county, or a town. What Mr. Glacken's conceded that his interpretation would essentially unravel 35 years of decisions from the Court of Appeals, finding that the General Assembly didn't intend for cities, counties, towns, and other public bodies to be subject to 7516. And that's a correct interpretation. It's a correct interpretation for a couple of reasons. The first one is you take a look at what the General Assembly has done since the passage of this statute. And I want to specifically direct the court to Chapter 75, Section 61(9). Now, that involves the Identity Theft Protection Act. In 2005, the General Assembly passed the Identity Theft Protection Act, and they defined who was covered by it. And one of the definitions was of a person. And when you take a look at definition number 9, person is defined to include government and governmental subdivisions. Now, why would they include governmental subdivisions in the definition of person if, according to Mr. Glacken, they're already corporate bodies and therefore covered within 7516? If we presume the General Assembly isn't going to add mere surplusage to its statutes, that addition either shows that Mr. Glacken's interpretation is incorrect or doesn't make any sense. But that's not the only place. If you look at Chapter 75, Section 39, at that point in the general statutes, the General Assembly has made it clear that providers of water can't also require you to buy electrical service at the time you sign up for water service. And they use the phrase providers of water and municipalities. Now, why would you include municipalities if they were also included as corporations under 7516, if his interpretation was correct? And the reason we know that public bodies aren't included is we go back to what was the settled understanding when this statute was initially passed. And when the statute was enacted in 1913, the antitrust laws were not applicable to public bodies. And in fact, they didn't become applicable to public bodies on the federal level until 1978 in the City of Lafayette case and 1982 in the City of Boulder case. So what the General Assembly would have understood in 1913 was that this would not apply to public bodies and would instead apply to persons, firms, or corporations operating in commerce. And the gloss of the Court of Appeals placed on that in the F. Roy Moore case was operating for profit in that area.
I always try to anticipate when I listen to one counsel's argument what the other one is likely to say. And again, just as I gave you a chance to correct me on my characterization of your position, he's got the right to correct my characterization of his. But at least my understanding of at least a part of his argument is that unlike most, if not almost all, local governmental units, this entity, the defendant in this case, is a for-profit entity in all but name and ought to be treated like that. And I think his argument in essence is let's look at the reality and not what the relative statutory provisions may actually say. What's your, assuming I have correctly characterized his argument, he told me I didn't correctly characterize yours, so you can tell me I don't correctly characterize his, but what would be your response to that argument, assuming that that's the one that he makes?
Well, I guess it would be twofold. First of all, let's take a look at what the requirements are for this hospital authority. I can't think of another for-profit company that has to comply with the Public Records Act, or has to comply with the Open Meetings Law, or whose board is appointed by the county commissioners, or whose financing is overseen by the local government commission and the treasurer, or whose financing has to be approved by the local government commission. Moreover, a for-profit entity, the characteristic of a for-profit entity is it distributes its profits. There is zero evidence and not a single allegation that profits are distributed by the hospital authority. What the hospital authority does, and we make, there's no debate about this, is it tries to charge more for its services than the actual cost, so it can take the margin and invest it in things like care for the poor, which it provides for at $1.5 billion a year. It can invest in hospital buildings. It can invest in salaries and research and the things that make it a premier organization. That doesn't mean it's for profit. That just means it's operating.
Is a for-profit hospital responsible for providing any uncompensated care?
No. As long as a patient is not in an emergency situation under EMTALA. If I've got prostate cancer, I'm stable, I'm not in an emergency situation, I walk up to a for-profit hospital and ask you to treat me, they're within their rights to say, we're not going to treat you. And what they'll do is they'll send me down the street to the hospital authority, because the hospital authority is going to treat me. That's what the hospital authority does. So not only are the profits not distributed, but the hospital authority is the safety net provider for the Charlotte-Mecklenburg area. And that's exactly the way the General Assembly envisioned it in 1943 when it established the Hospital Authorities Act. It's particularly relevant today because we've included that at page 408 of the record. When you go back and read it, the General Assembly wanted to provide for care for the poor, medical care for the poor, and they also wanted a hospital authority in the large metropolitan areas to be available to combat epidemics. And of course, we're in the largest epidemic in over 100 years, and the hospital authority has done precisely that. It's been on the front lines, it's continued to provide uncompensated care, and it's been operating as the public body it was envisioned. There is no hint or allegation in the complaint that somehow this public body has converted, I guess under dark of night, to a for-profit entity. There's nothing for-profit about it. And in fact, there are very few for-profit entities that would permit all of the governmental requirements that the hospital authority has in terms of open meetings, public records, and state overseeing financing of its revenue bonds and revenue notes.
Council, there are clearer examples of even in terms of cities and towns certainly being able to enjoy the type of immunity from certain kinds of matters, such as the one that we have here, where cities and towns may at times be said not to be operating in their governmental capacity, but operating in their proprietary capacity, such as, for example, trying to handle blighted areas in their cities or towns. Are you saying that under all circumstances, there would be blanket immunity for your client, or are there situations where, just as with those cities and towns in the example that I'm giving, that there are not ways where your client could be performing in such a way that when you consider actions of or affecting commerce, that that kind of immunity that you're asserting would not apply?
Justice Morgan, that's an excellent question because it brings up a couple of concepts that I'm afraid have gotten confused in the briefing. We're not advocating that the hospital authority has immunity from anything. The hospital authority is subject to the federal antitrust laws, it's subject to the state antitrust laws. The only question in this case is whether a private party can sue the hospital authority for treble damages. Hospital authority can still be sued for breach of contract, for fraud, for tort, for any number of things. So this isn't about immunity, which is why the proprietary versus governmental analysis really doesn't carry over. This is an exemption from being liable to private parties for treble damages. And you see a similar exemption at federal law, where local governments and special function units of government are also exempt from money damages, but they're still subject to claims for injunctive relief. We're still subject to investigation by the Attorney General under Chapter 75. The Attorney General is still free to bring claims for injunctive relief under Chapter 75. So there is no immunity from the antitrust laws. What we are saying is that the General Assembly did not intend public bodies to be liable to private people for treble damages in 75-16.
Could a private person seek injunctive relief under Chapter 75 from your client?
Yeah, that is a really interesting question because when I read 75-16, it creates the private cause of action. So I think the question would be, could a private party acting in the shoes, for example, the Attorney General, bring a claim for injunctive relief? You know, 75-16 doesn't even talk about injunctive relief. It just simply talks about treble damages. So I think that's an open question. I don't think finding that the hospital authority is exempt from private suits for treble damages is necessarily a conclusion that it would be exempt from claims for injunctive relief, as it is under federal law.
So you're not asking us to hold that a private individual could not bring an action for relief other than damages against your client at this point?
That's correct, because that's really not before the court. The only issue before the court is their claim for private treble damages under 75-16.
Mr. Kearney, just to follow up on on Justice Morgan's questions for a minute, is it relevant at all that specifically in this case, what Atrium is being sued for really is not governmental at all? It's engaging in pure profit maximization by allegedly entering into these anti-steering contracts. Does that not matter at all, that it's clearly being sued as a market participant rather than a government?
Well, I guess but understanding that I don't necessarily agree with the characterization about pure profit maximization, we think there are pro-competitive reasons for these. Now, understanding you've got to take the complaint on its face, and I'll get to those in a second. But I don't think it matters for this reason, because the General Assembly found, and it's all over Chapter 131E, that the provision of medical care is a public purpose. And as long as it's carrying out this public purpose, then it is a public body which is exempt from money damages under 75-16. And to put a little finer point on the characterization, understand that this is a claimed vertical arrangement. So as a vertical arrangement subject to a rule of reason analysis, they contend these agreements are anti-competitive. We contend they're pro-competitive because it permits you, Justice Davis, to go to the doctor you want to go to, and if he says, I need to do surgery and I want to do it at this hospital, the insurance company doesn't have any business saying, you're not going to that hospital because this hospital is cheaper. So while there's an allegation of profit maximization for a small segment of the population, The fact of the matter is lots of governmental entities are market participants, depending on how you want to define that. For example, our cities collect garbage. They're private garbage collection systems. The airport authority, they're certainly private airports. It is difficult to think of a function of government, even in education, that you cannot describe as being a market participant or participating in a market of some kind where there are private participants. So I think that's a very slippery slope you begin to go down in the 21st century when you start trying to distinguish between market participant by a government and other functions of a government.
So your argument ultimately is that they're exempt under Chapter 75 from any type of allegation at all under the sun.
No, my argument is they are exempt from treble damages by private persons.
But there's nothing that could be alleged by a private party that would subject them to the possibility of treble damages.
Correct, under 75-16, that is absolutely correct. Now, again, they can be sued for fraud. The things that may be an unfair trade practice, they can be sued for at the common law, but they just simply cannot be subject to private suits for treble damages.
I also wanted to follow up on Justice Morgan's question and what you were just saying about the implications here. How far does this go in terms of the types of quasi-governmental bodies in the state that may be creations of state government, county government, city government that then would be impacted by this decision that they're not covered? I mean, for charter schools, for example, you mentioned education. Are charter schools quasi-governmental bodies that then don't have any protections under the statute?
I don't believe they are, because the hallmark of this, and I go back to the Byrd case, is this a public body and body politic and corporate. Those are the magic words. So when you see those words, and Byrd talks about it, certainly the Greensboro Airport Authority case talks about it, those words connote acting in the place of a government, doing ancillary functions of a government. Most charter schools, in fact, I think very few charter schools, for example, are chartered as bodies politic and corporate, or as public bodies. Now, there may be some strings attached to some of the public financing, but they are not public bodies. And it's that kind of thing that's important. And in fact, I believe charter schools are specifically defined as private for purposes of Section 501A3. So I think what you're looking for to be a public body is got to say in the enacting instrument that you're a public body and body politic and corporate. That's how we define cities, towns, counties, and these political subdivisions, such as airport authorities. If I can, what I'd like to do is take the 3 or 4 minutes and talk about the other issue that's before the court, which is the hospital authority's appeal of the business court's decision under Article 1, Section 34 of the North Carolina Constitution, which we refer to as the Anti-Monopoly Clause. The Anti-Monopoly Clause obviously prohibits monopolies. We believe that this complaint is insufficient to state a claim under that clause when you take a look at American Motors versus Peters and the City of Morganton cases. Article 1, Section 34 does not require you to be a complete monopoly. In other words, you don't have to have 100% of the market. But what it does require is more than is alleged here. We've cited to you an abundance of law that indicates that a 50% market share, which is what is cited in the complaint, is insufficient to confer monopoly power. And that's what the clause is directed at. It is directed at monopoly power that is so significant the monopolist controls prices. There's no allegation that we control prices. There's no allegation.
Mr. Cooney, what does control prices mean in your view?
Control prices under federal antitrust common law Control prices means more than charging more than what people say. In other words, it goes beyond simply charging a super competitive price. It's actually setting a price or the ability to set a price. And that's what justice.
Are you then suggesting that you only control the price if the other people have to charge the same thing you do?
No. And in fact, there's no allegation that our other competitors are required to charge the same thing. But for example, and going to the Chief Justice's analysis in American Motors about horizontal agreements, if, for example, the hospital authority and Novant, who's its main competitor, agreed they were only going to charge $5,000 for a hip replacement. They were always going to charge $5,000. They would never charge below it. That would be a horizontal agreement in which they're acting as a monopolist and setting a price. They control that price. And since they would have a market share between them of roughly 75 to 80%, the hospital authority's participation in that would be against the provisions of the anti-monopoly clause. So controlling prices means more than just charging a super competitive price. It means being able to impose prices. The other thing you look for in a monopolist is, can you exclude competition? Can you keep competitors out of the market? And again, there's no evidence of that and no allegation of that in connection with this case. Justice Ervin, did that answer that question?
As best my limited mentality is able to take care of it, yes, sir.
Well, then I apologize if I was less than clear. I would like to save the remainder of my time for rebuttal.
Mr. Kearney, one last question on that. At what point does it become a question of fact versus a question of law on what is and is not a monopoly?
It's probably when you get into the range of a 70 to 80% market share. You can approach market shares which give you monopoly power. You really don't need to draw the line in this case because there's no allegation in the complaint that we have monopoly power. There's no allegation in the complaint that we set prices. And there's no allegation in the complaint that we have a market share that's greater than 50%, and no court has ever found that a 50% market share is a monopoly.
So if they'd added one more line to the complaint and alleged that you do control prices, and perhaps they'd taken out the 50% figure, would that be enough to get by 12B?
It probably would be if they had made those allegations. If they alleged we had a monopolist control of prices, if they didn't include our market share, which would be antithetical to that, and if they alleged the other things that are necessary to show that we have monopoly power, which is different than market power, then that probably would have been sufficient to state a claim for 12C purposes, and then we would be doing discovery to show why on Rule 56 they didn't have a valid claim.
Thank you.
All right. Thank you, Mr. Cooney. Mr. Gloughman.
Thank you very much, members of the court. So first of all, I'll get to those anti-monopoly clause issues in a moment, but I want to start by just turning back to the Chapter 75 issue. And I want to talk for a minute about the arguments that have been made about the purpose of the legislature and this suggestion that we should be reticent to have the antitrust law, have a private damages remedy reach bodies, politic, and corporate like Atrium. And I want to point out a few things. First of all, on this intent of the legislator issue, the court addressed this in Jackson versus Housing Authority when it ruled that given that the wrongful death statute was passed after the definitional statute was passed, it had to believe that the legislature clearly understood that the word person would draw within it the housing authority. So that argument is simply belied by this court's own precedent. But more fundamentally, I guess what I want to say is that I don't think it's the public policy of this state to be hesitant about applying the antitrust laws to public entities. And I also don't think that this court has ever held or believed that there's such a thing as too much competition when it comes to public services. Think about all the things that Mr. Cooney was mentioning: water, garbage, power, sewer. Those are the kinds of services that they're fancy and they don't make it into fancy court decisions. But when you talk about what hits ordinary people in the wallet the hardest, it's those things. It's cable television. It's those checks you have to write every month. And that's why this court has historically applied the anti-monopoly clause to prevent the granting, for example, of exclusive franchises. Mr. Cooney says that the common understanding at the time that the North Carolina antitrust laws was passed was that antitrust laws don't apply to public entities. You don't really have to look any further than the North Carolina Constitution to see that that's not true. You could actually look at the anti-monopoly clause in the North Carolina Constitution as an enabling constitutional power for this legislation.
I was going to ask you this later, but I'm going to ask it now. Then, are you equating the anti-monopoly clause in the Constitution with the Sherman Act?
Oh, that's a really good question, Your Honor.
Because I think particularly that goes to the second issue: is what does that clause mean? Does Article 1, Section 34 constitutionalize federal antitrust law?
So this court has never so held.
Are you asking us to?
We have not made that request. But if the court were to hold the defendant's way of Chapter 75, then
if you're not asking us to, what's the difference between constitutionalizing the Sherman Act and Article 1, Section 34 that you are asking us to hold?
Well, I guess when you say constitutionalizing the Sherman Act, what I'm mindful of is that this court's decisions under the anti-monopoly clause have sort of followed two strands. One is they have, and in one respect, they're actually broader than the Sherman Act. One strand that they've followed is they have condemned government action that is based solely on the notion that less competition is better for some reason. And that has been held since Thrift, I believe, since Thrift versus Board of Commissioners, all the way through to In re Aston Park, all the way through to Madison Cablevision, all the way through to American Motor Sales. When the government, if the government says we're doing this because we think there's too much competition or competition might be harmful or bad, like there might be too many hospital beds, that is simply condemned without much further analysis.
So is your argument then that Article 1, Section 34 condemns anything that reduces competition?
Well, if there is not a what your decisions have said is, if there is not a justification for it, a public welfare justification for it that isn't tied to restraining competition. So for example, in Madison Cablevision, in American Motor Sales, when the court examined the facial validity of the statute, it said it's key here that the purpose of this statute is not to restrain competition between the brands or even really to restrain competition between dealers. It's to correct this bargaining discrepancy between franchisors and franchisees in the automobile space. And because it serves that purpose that isn't about restraining competition, we can't condemn it as facially invalid. However, in re, for example, if you look at in re Aston Park.
So again, to follow up on that just a second, and I apologize for drawing you away from where you're probably intending to go. In the event that there had been a showing that the statute and regulatory decisions at issue in American Motors had in fact somehow reduced competition, that would have been enough to by itself to have invalidated the statute or regulatory decision at issue in that case?
No, I don't think that's right, because I think there's like, the way I read American Motor Sales is there's a sort of facial analysis and there's an effect in fact analysis.
And unfortunately, the second comes before the first, so we're confused that way too.
And the effect so the facial analysis asks, is this statute, whatever anybody says about it, is it really just about restraining competition, or is this government action really just about restraining competition for the sake of restraining competition? And the court said in In re Aston Park that was not a valid basis to restrain the expansion of a hospital, because too much competition. Listen, the problem we have with healthcare in this country is not too much competition, right? Hospitalization bills are the #1 cause of personal bankruptcy in this country. I suspect that's probably true in North Carolina as well, right? Too much competition for hospitalization is not the problem. So in Madison Cablevision, the court, in American Motor Sales, the court said, unlike in Ray Aston Park, unlike State versus Harris, unlike these other cases, here there's a public welfare justification that isn't just about restraining competition. So it's facially valid. On the effects side, what the court said is, and in that respect, frankly, I mean, it's broader than the Sherman Act because it has to be broader than the Sherman Act because the anti-monopoly clause reaches the state. It reaches the state qua state. On the effects side, what the court said is you have to, the court basically imported a modern antitrust analysis of what monopoly power is and asked, does this revocation of this franchise create a monopoly in fact? And then the court found that because there were lots of other Jeep dealers in adjoining counties, because there was interbrand competition between Jeep and Jeep vehicles and Chrysler vehicles or Chevy vehicles, that there was no plausible allegation or finding that a monopoly in fact had been created under the standard of stifling competition, controlling prices, et cetera. So that's how I read this court's, and actually, you know, it takes some careful study, but this court's anti-monopoly clause jurisprudence hangs together remarkably coherently in terms of these two strands of facial invalidation of statutes or government actions that don't have a purpose other than restraining competition. And then on the other hand, looking at whether or not a monopoly in fact has been created.
Mr. Blacken, you've alleged that Atrium only holds a 50% market share in the area and that you've conceded the existence of 6 competitors. Can you cite us to any case in which a court has held that those circumstances are sufficient to constitute a monopoly?
You know, what I'm going to cite you to, Your Honor, is first is the April 11th, 2017 order of Judge Robinson in which he rejected this very argument. And he found that our allegation of approximately 50% market share in combination with our allegations about the ability to control prices. And
I'm sorry, I am familiar with Judge Robinson's order, but I'm asking you, can you cite us to any cases from other courts that have held this is enough?
No, I want to be clear that it's the order that I'm talking about isn't the one that's up here on the petition for cert. He's addressed 2 motions by them for judgment on the pleadings. The first one that he decided in 2017, he rejected these arguments. This is the 2019 order. And on the 2019 motion, the only argument they made is that competition has to be completely eliminated. They didn't make any of these market power arguments, market share arguments. They made those back in 2017 and he rejected them. And they haven't even given his order explaining his reasons for doing so.
I'm sorry, my question is, can you cite me to cases from other courts?
I'm happy to, Your Honor. I'll cite you to Judge Robinson in his 2017 order, which they filed a cert petition on that was denied, cited Broadway Delivery Corp. Versus United Parcel Service, 651 F. 2nd, 122, which is a Second Circuit case holding that market share evidence receives only weight and is not conclusive one way or the other in a monopolization case. He cited also Colon Industries, KOLON, 748 F. 3rd, 160, 4th Circuit, 2014, quoted it for the proposition that there's no fixed percentage market share that conclusively resolves whether market power exists. And when Mr. Cooney tells you the contrary, he is just...
I hate to be persistent, but I guess I'm going to get bad enough not to try. Can you name any decision of a federal court or a state appellate court that holds that a showing of a monopoly had been made at a 12B6 stage, at a summary judgment stage, or at trial, when the allegations or evidence showed no more than a 50% market share? I'm talking about general language. I'm talking about the holding of a case.
Okay, this is what Broadway Delivery Corp says. It says, sometimes, but not inevitably, it will be useful to suggest that a market share below 50% is rarely evidence of monopoly power. A share between 50 and 70% can occasionally show monopoly power, and a share above 70% is usually strong evidence of monopoly power.
Is the holding of any case that finds the existence of a monopoly for purposes of either state law or Sherman or Section 2 of the Sherman Act, is there any case that you can cite that holds that a monopoly existed when you had only a 50% market share? And I'm not talking about the theoretical possibility, I'm talking about in actuality.
I'm sorry, Your Honor, I cannot. They did not raise that issue in their opening motion. They did not raise that issue until reply. They did not raise it before the court below on this order. And it is not something I came here prepared to address. If you would like,
that's fair. I mean, but you don't know that there's not one, but you can't tell me that there is one. Is that what you are?
That is what I'm saying. And I would, on this point about power, so monopoly power. First of all, monopoly power is simply a large degree of market power. The definition of monopoly power, definition of market power is the ability to price above cost, above competitive levels. The definition of monopoly power contained in many cases, including United States versus Microsoft, for example, that we cited, is the ability to price substantially above competitive levels. How do you prove that? One way to prove it is what's called direct evidence, where you don't look at market share at all. You simply look at the prices, and you compare the defendant's prices to what you believe the prices would be in a competitive market, if there's evidence of that. And you can look at things like cost, you can look at things like the prices of other competitors, and we allege throughout our complaint that they price substantially above cost. And by the way, I want to point out something else, which is that we're now in the middle of class certification, and in our class certification expert work, our expert has opined that the Atrium has a 64% share of the relevant market by revenue. I mean, of course, that's not in the complaint because we pled the complaint years ago. But if the court had decided this issue, if this issue had been presented to the court on this motion, we would have asked for leave to amend to increase that number to 64%. And that is I don't usually bring out waiver arguments in an appellate situation because I know the court wants to get to the merits, but this is beyond waiver. I mean, this is an argument that was actually made and rejected years ago and that we haven't had one opportunity to address. And if we went back down on that ruling, we would be asking Judge Robinson for leave to amend the complaint to allege 64% market share, which is what our expert has found in our class certification briefing that is on record with the court. So I apologize. I got a little worked up there. What I was trying to explain was there's what's called direct evidence of monopoly power, which is just the evidence about pricing. If you can prove that, you don't get to market share at all. You don't get there.
Let me also ask you about the distinction that Mr. Cooney's raised between horizontal restraints and vertical restraints. Do you contend that distinction is totally irrelevant? And if so, what authority do you rely on?
So that I contend that is that these are horizontal restraints, as that term has been used by this court in decisions interpreting the anti-monopoly clause, because they restrain Atrium's competition with its horizontal competitors, which are other hospital systems, because they prevent other hospital systems from offering insurers the option of creating a narrow network that will cost less. So they are a horizontal restraint in that sense. And that is the distinction that's being drawn by American Motor Sales. Is the government activity restraining competition, which is always horizontal, or is it regulating a vertical relationship? And the court said in American Motor Sales, it is crucial to our holding to understand that this arrangement, this dealer protection law, is regulating the vertical relationship between franchisors and franchisees. On the anti-monopoly clause, then, I have very little time left. What I would like to close by pointing out is that this court held in State versus Harris Sort of in service of this point that the court should not be reluctant to extend the antitrust laws to municipalities. This court held in Thrift versus Board of Commissioners that there are no more pernicious monopolies than the ones that are associated with municipal corporations. And it's precisely because of the ability of municipal corporations to impact the daily life of their citizens and to impact it in ways. Yes, there can be few, if any, monopolies more dangerous in their tendencies and unjust and harmful in their results than those that pertain to municipal corporations. And I would submit to you that, as I said before, the problem we have in this country is not that there's too much competition in healthcare markets. That's not the problem of North Carolina. That's not the problem of the members of this class. The problem is we have too little. And the anti-steering clauses that Atrium has imposed on insurers are preventing the free competition that the public policy, the laws, and the Constitution of the state of North Carolina demand. Thank you.
Thank you, Mr. Blackman. Mr. Cooney. Mr. Cooney.
You're muted again.
I'm sorry. Justice Davis, I'd like to go back to your question about vertical versus horizontal, if I might, because Mr. Glacken has said something very different than his papers say, and that his papers said in 2017, the order he keeps wanting to talk about. The issue before Judge Robinson in 2017 is whether his clients as indirect purchasers had standing to bring a claim under state law. Under federal law, they don't. Indirect purchasers cannot bring a federal antitrust claim. Indirect purchasers are necessarily purchasers in a vertical arrangement. So, and he conceded at that point that the agreements he was talking about were vertical arrangements. And here's what the complaint says. The complaint says in its dealings with insurers, Atrium uses anti-steering clauses. And we'll take on its face their allegation that that restrains some degree of price competition by the insurance company. And what he says is the insurance company can't send people to cheaper alternatives, or the insurance company can't come up with different pricing. Now, the insurance company is not a competitor of the hospital authority. The insurance company is in a vertical relationship with the hospital authority. These agreements don't govern at all what Novant or Caramont or any other hospital does. So this is a vertical arrangement, which is very important because it's subject to a rule of reason.
However, Mr. Cooney, if I understood what Mr. Glacken said earlier, and he doesn't now have a chance to correct me, so I guess he's at my mercy. If I understood his argument, he said that while the any steering provisions were not classic horizontal restraints in the same sense that a price fixing agreement would be, that they did in fact have a definite horizontal impact, and that therefore in his view they shouldn't be treated as vertical as compared to horizontal restraints. I think that was something close to his argument. What would be your response?
Well, that's every vertical agreement, because by definition a vertical agreement suppresses competition. And who's going to suppress competition? It's not going to suppress competition among purchasers. It's going to suppress competition in the industry, which is why this kind of vertical relationship is subject to a rule of reason analysis. And Justice Exum was very specific about the horizontal restraints, which is subject to a per se analysis. There is no one who contends that these agreements are subject to anything other than a rule of reason analysis, which means he's got to show they're anti-competitive. We get to bring forward evidence that they're pro-competitive, and at the end of the day, he bears the burden of persuasion. In per se, which are horizontal agreements, once you prove the agreement, you've proved harm. You're not allowed to show pro-competitive benefits in a per se arrangement, which is why Justice Exum talked about it.
Because we're on Rule 12, why wouldn't he be allowed to go forward on that?
Well, because he hasn't pleaded it. He hasn't. What he's done when you read his pleadings on Article 1, Section 34, what they say, essentially is we have agreements with insurance companies. Because of the agreements with insurance companies, we charge supra-competitive prices, which is an antitrust allegation. But there's no contention we charge monopoly prices, or that we have a monopoly market share, or that we have established a monopoly, or that we have excluded competitors or eliminated competition. In fact, the papers show that Novant and Caramount compete fiercely. They have their own members and their own agreements with the insurance companies. They compete to be in network in the same way that the hospital authority does. So when you take a look at the face of his complaint, what we're saying is under the anti-monopoly clause, he's got to show monopoly or monopoly power or act which will lead to monopoly power. And he has not done that. And those are the parameters of Article 1, Section 34. It doesn't constitutionalize every aspect of the Sherman Act. And that's where the business court made the mistake, because the business court essentially said, if you suppress competition, that is enough for Article 1, Section 34. And it's not. You've got to suppress competition either because you're a monopolist or because you've got the power to do so, which will lead to you being a monopolist. And those allegations are found nowhere in the 4 paragraphs that constitute his second claim for relief on Article 1, Section 34. So we don't think Article 1, Section 34 was intended to constitutionalize all aspects of the Sherman Act. It couldn't have been, because it was enacted 100 years before the Sherman Act. But certainly, when we go by what it's called, the anti-monopoly clause, those monopolization allegations are necessary to be able to state a claim. And I'm out of time, but I'm happy to answer any questions the court may have. Thank you for your patience.
Thank you, Mr. Cooney. Thank you, Mr. Glasgow. Madam Clerk, would you recess us for 15 minutes, please? Madam Clerk, you're muted.
I'm glad somebody else did that.
There we go. Now we're even, Mr. Cooney. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess for 15 minutes. God save the state and this honorable court.
Awesome. We are back at 11:59.